Hello. Before we get into the legal battle over CalSavers, video number 4 in our series, I'd like to make an important update known to you. The original video was recorded back in June of 2020 when President Trump was still our president and his Department of Justice was on the side against CalSavers in the courts. You'll see more about that in the video to follow. But obviously things have changed. We now have President Biden in office, and his Department of Justice has in February filed a withdrawal of the opposition to CalSavers. That does not solve the legal battle. It's still ongoing in the appeals courts. So I think most of what you'll see in the next few minutes in the video will be helpful to get a understanding of the legal battle around CalSavers. But the federal government is no longer siding against CalSavers. Enjoy the video. Hello again, this is Ed McClements, and in video 4 we're going to talk about the legal battle over CalSavers. The CalSavers program has been in the works really for a very long time. It was all the way back in 2008 that Assembly member Kevin DeLeon put forth the first set of legislation that would lead to the CalSavers program. It was decided that a lot more research needed to be done into the matter, so the state government funded a number of investigation studies that would help inform the legislature as to whether or not a program like this could be constructed and what the value would be to Californians for the long term. It was then back in 2012 that the real meaningful legislation that would form the underpinnings of the CalSavers program was passed and approved by the state governor. But it was actually another 4 years after that legislation passed that it would actually be signed off as an implementation program by Governor Brown. 2 years after that, it was decided that the CalSavers program would be contracting with an outside firm called Ascensus to provide all of the day-to-day management of the program. Also, the independent advisory firm of State Street Global Advisors was hired on to handle the management of the investment funds that would be part of CalSavers. Now, the entire concept of CalSavers has come under some scrutiny, and whether or not it has full legality under U.S. federal law. Under U.S. federal law, there's already a body of work called ERISA, the Employee Retirement Income and Security Act of 1974, was supposed to give all employers throughout the country, no matter what state they're in, a set of rules and procedures that they would follow if that employer decided to offer a retirement plan. ERISA did not mandate employers to provide retirement plans, but simply said, if you're going to make the promise to your employees of a retirement plan, then these are the rules and procedures you must follow to be in alignment with federal guidelines for how such plans should operate. Now, what follows is a very simplified version of a pretty complex set of circumstances. I'll do my best to just hit the highlights. It was in May of 2018 that the Howard Jarvis Taxpayer Association decided to sue the state of California for starting up CalSavers. This case was assigned to the federal district judge, Morrison C. England, to make the review. His decision came out in March of 2019, and it was pretty decidedly in the favor of the state of California in its opinion of how ERISA worked. In other words, this judge did not think that California's CalSavers violated employers' rights under ERISA. But the judge did give the plaintiff, Howard Jarvis Taxpayer Association, the opportunity to amend their complaint to see if there were still some other issues that needed to be fleshed out in this judicial review. Things got interesting when, in September of 2019, the U.S. Department of Justice decided to weigh in on the matter, and it sent in a statement of interest on the topic to help persuade this judge that ERISA did supersede California's right to create a CalSavers program. Obviously, the state of California had a different legal opinion. They submitted their own statements of interest through the California Attorney General's office. But early this year, in March of 2020, Judge England issued his final decision on the matter, and it was in his opinion that yes, California does have a right to insist on employers participating in the CalSavers program or offering up their own alternatives. As was likely to be predicted, the Howard Jarvis Taxpayer Association has decided to appeal this decision up to the next higher level of court, which is the U.S. Court of Appeals. When you get into the weeds on this, there are some other issues that need to be considered. It has been since 1975 a position that ERISA was not going to apply to employers that had simple programs such as a payroll deduction IRA arrangement. The Department of Labor had developed a safe harbor test with 4 levels of concern. The first part of the test is that no employer contributions are allowed in the program. Number 2 is that the sole employer involvement was in the collecting of the contributions that employees made through payroll deduction and remitting those to the appointed IRA custodian for that employee. They could also publicize the fact that there was such a program, but they needed, as an employer, not take a position of endorsing the program or encouraging the employees into participation. The third part of the test is that the employer receives no compensation for their role in participating in the payroll deduction IRA. And the fourth part of the test is that the employee participation is completely voluntary. But that brings up an issue as to whether or not a payroll deduction IRA that incorporates the new concept of automatic enrollment, would that be something that would jeopardize whether or not the Department of Labor saw this program as truly voluntary or not? The Obama administration became aware of this issue and sought to give support to these state programs. So back in 2016, they had the Employee Benefit Security Administration, part of the U.S. Department of Labor, issue a new safe harbor that would allow these state-sponsored payroll deduction IRAs to incorporate automatic enrollment provisions and still be protected from having to trigger an ERISA plan status. But then when President Trump was elected, he made pretty sweeping changes to a lot of the regulations that the Obama administration had put in right at the end of their term in office. In particular, this joint resolution from the House of Representatives and the Senate specifically dealt with the issue of this safe harbor rule. So in 2017, this Congressional Review Act was allowed to strike down the Department of Labor's 2016 safe harbor regulation regarding ERISA plans and how that applies to state-sponsored IRA programs. This issue was very well understood by the California government. In fact, they asked for and got a legal opinion from the firm of K&L Gates that helped make sure that the program was still on solid legal footing. These are the first 3 pages of that in material. We've talked about some of this in an earlier video, but I'd like to dive in a little bit deeper and show you in this letter from the law firm of K&L Gates. So we're going to take a quick look at this link. So in this document, it's got 21 pages of information. There's a cover letter here, and then the actual letter from K&L Gates is on the next page. We're going to scroll down through a few pages and get down to page number 9. In this section, we start talking about the law firm's review of ERISA. They go on to talk about the 2075 safe harbor by the Department of Labor on how they saw the issue of payroll deduction IRAs. They also go on to talk about the 2016 safe harbor and that Congressional Review Act by the Trump administration, which negated the 2016 safe harbor. And that analysis carries over for the next couple of pages. They even go into some discussion about how the courts would basically take a look at a situation as we currently have with that 2016 safe harbor being removed. What's the default position and how would a judge decide on where the status of ERISA preemption would fall currently. So they go on to finish. The law firm of K&L Gates states in point number 2 that the program should not be considered an employee benefit plan subject to ERISA. However, as discussed above, the final determination on whether the program is subject to ERISA rests with the courts. They go on to finish this paragraph with the statement, while we believe it is unlikely at present, it is also conceivable that the Department of Labor may take an enforcement position against state auto IRA programs such as CalSavers. So where does that leave an employer in terms of making a decision on CalSavers or setting up an alternative? Well, the truth of the matter is we're a little bit between a rock and a hard place. California's got its point of view, and the federal government has its point of view. When we analyze this situation, we have the following key points. State authorities here in California have already made it clear that they plan on penalizing employers that are not in compliance with the CalSavers program. The deadline for compliance for employers with 100 or more employees is set up to be September 30th at this point in time. We think it's unlikely that the state will act aggressively against employers who have registered with the CalSavers program with the fact that they have an alternative program in place. We've also taken careful steps to make sure that the Easy Savings for You program have closely mimicked the way the CalSavers program is set up. In terms of taking a look at the federal government, we think that it's unlikely that the feds will try to challenge any payroll deduction IRA program that a California employer sets up simply on the basis of activating the automatic enrollment feature. Also, we think there's no penalty that the employer would face if the Department of Labor decided to investigate a payroll deduction IRA with automatic enrollment and somehow decided that it was requiring ERISA compliance. And the bottom line is that the Easy Savings for You team will be here to help you deal with any confusing issues that come down the pike after having set up your program, whether that be through state regulators or through the federal government's Department of Labor or IRS. So as we wrap up this video, let's recap our key points. CalSavers is supposed to protect employers from exposure to ERISA requirements. But CalSavers has taken a legal position that so far has been held up in the federal courts, but it is somewhat controversial. The U.S. Justice Department has taken a firm stand that CalSavers is preempted by the federal law ERISA. And the DOL has not yet stated whether or not automatic enrollment, when coupled with a payroll deduction IRA program, will somehow jeopardize the freedom from having to deal with ERISA guidelines for payroll deduction IRAs. The bottom line is we will be awaiting a court decision from the U.S. Court of Appeals, and depending on that decision, there's a high likelihood that decision would be appealed to the next higher court, the U.S. Supreme Court. Since all of that's going to take a considerable amount of time, it's important to keep in mind that at this moment in time, this is the law of the land in California. Employers are going to have to either participate in the CalSavers program or face penalties or have an option that qualifies as an alternative.